Sam Seder on the Majority Report. Emma Vigeland out for the day. Joining us now, Wendy Parmet. She's a professor of law, public policy, and urban affairs at Northeastern University. I said Northwestern earlier. She's the author of Constitutional Contagion, COVID, the Courts, and Public Health. Welcome to the program, Wendy.
Thank you so much. It's great to be with you.
Let's just go through, before we get into the sort of the questions of the law, broadly speaking, the concept of social determinants of health. When we talk about public health policy, what are the things that public health policymakers generally look at when they're assessing what impacts public health?
Sure. So, I think in the United States in particular, but elsewhere too, we tend to think of health these days primarily as an individual matter, right? Why am I healthy? Why am I sick? What did I do right? What did I do wrong? What's in my genes? And there's value to that. And we certainly want our physician to think that way. And we want our physician to treat us when we're not well. But as a public health, when we turn to public health, we're not thinking about why did one person, Wendy, get sick or not sick? What can we do to treat Wendy or not treat Wendy? We're looking at what makes a population. It could be a community. It could be a part of a community. It could be a city. It could be a state. What are the factors that are influencing the health of this larger group, of this population? And when we look at that, we take this sort of broader perspective, this population perspective. What we're seeing and what we're understanding is that a whole range of social factors really influence how that population does. Is it healthy? Is it not healthy? Is it healthier or less healthy than folks in a different population? And these are the social determinants, the social factors, structural racism, pollution, housing, employment, and I like to add law, that affect the health of the community or a community, as opposed to what makes a single individual healthy or not.
How, and you're adding law into this mix, you're coming obviously from a legal perspective, yeah. But how, in terms of the development of this understanding of public policy, public health policy, these different elements, I imagine, that you just outlined have entered into the equation with the more data that we have had, and as a social science has developed over the years. And you're suggesting that law in particular has been left out of the conversation and needs to be considered in this, and it is having a direct impact on our public health. That takes me to the title of your chapter 2, Salus, populi, suprema lex, which means let the welfare of the people be the supreme law. When we look back in U.S. law, broadly speaking, was that ever, in fact, the law of the land? I mean, did that diktat that has been around for, I guess, 400 years. What did our legal system reflect that concept?
To a large degree. Now, I need to make a bunch of caveats, because if we go back to an earlier period, the understanding of what legal decisions, what policies would affect health was obviously very rudimentary, right? If we're going back into the 19th century and even before then. And obviously, we can point to a lot of things in this earlier period where the legal system really hurt health and exacerbated health inequities, right? I mean, the law's tolerance of slavery for a very long time, and then Jim Crow is example number one, but I can give other examples. But what I am trying to say, and what I'm trying to recall in the book, is that the idea that the law should protect health, and that judges should consider health and give weight to the community's health in their decision-making, was widely followed, both at especially at the state level, but also at the federal level in constitutional law. And it was taken for granted, right? I mean, this was a dictum that many judges cited, but even when they didn't cite it, you could see this in the deference they gave to health. You can see this across a wide number of legal doctrines and theories until the middle of the 20th century.
All right, let's go back to some of that early, to some of those early, I guess, examples of that. But I mean, I think this, like, this concept. I mean, because there's like the law as manifested through judges and in our legal system may not have had the level of sophistication to appreciate that slavery was a health issue as well on some level, right? I mean, because they did not consider slaves to be anything other than a commodity at that time. And so the idea of the health of this commodity is, the same way that you would talk about, I guess, depreciation for a piece of equipment, et cetera, et cetera. But when it came to specifically questions of health, this concept that the welfare of the people is paramount. Can you talk about, like, I guess, in conflict with what? I mean, what it's like, I mean, because on some level it seems like obvious, like, of course, that the welfare and that's probably a broader meaning than just health of the people should be paramount, but specifically relative to what sort of like a strain that has existed within the context of the law.
Well, it's a great question, and I think it's important to understand that I think we often think of the 19th century as this period of laissez-faire, rugged individualism, no regulation. People did their own thing. People took care of themselves. And in fact, that's not true, right? That in fact, the earliest, especially the antebellum period, was a period of significant regulations. Now, we didn't have the kind of complex bureaucracies, and we didn't have the complex federal bureaucracies that we have today. But all kinds of manner of things were regulated, from the quality and the weight of bread to vaccine mandates going back to the 1820s, sanitary measures. And all of these different laws were not assumed, especially if I'm going into the antebellum law, to be in conflict with what we today think of as individual rights, including property rights, because people simply didn't have rights to do things that were considered detrimental to the common good or the public's health. And so you had just a lot of regulations. They would come and go. They would be more or less effective, more or less scientifically grounded. But
were these local or federal, or were they local that was edified by legal tests on a federal level? Like, where did these emanate from, these regulations?
In the antebellum period, or pre-Reconstruction, they were mostly state and local, right? You did have some federal, but not a lot. It was mostly state and local. Localities and sometimes states enacted quarantines. They regulated businesses. They took care of sanitary measures. You just had a sort of a wide swath of One of the terms that was often used is you had a well-regulated, well-ordered republic, right? A well-ordered state. And these measures, for the most part, were just not seen as conflicting with individual rights, because the idea that there were rights against the public, very common idea today, right? I mean, the idea that the government does something, it violates my right, I'm an American. This idea that our freedom comes prior to the well-being of the public was not a very well-established, it was still nascent. Before the Civil War, it begins to develop during Reconstruction. And so then the first time when you start getting the Supreme Court really beginning to develop the relationship of constitutional rights, particularly the rights protected by the by the Reconstruction Amendments, and individual rights, and public health. But this is not there at the beginning. And what has happened now is we've gone to a place from sort of no recognition of individual rights, or barely any, to a place where, as I describe in the book, individual rights continuously trump the public's health, and not just trump it in individual cases, but leave governments increasingly incapacitated to respond to the social determinants of health and even to pandemics. So we're kind of left to be on our own because our law now makes it increasingly difficult for governments to respond.
And I think what's important for people to understand is you're talking about the law as it's interpreted, because the laws have not changed in this regard. When we talk about the constitutional amendments in the wake of the Civil War and Reconstruction, constitutional amendments, they haven't been updated.
Right.
It is really the interpretation. So describe to me like how 13th, I presume mostly 14th Amendment, 15th Amendment, how they developed. It's almost like they were upended. And I wonder if it was also like, what is that a function of? Because one of the cases that you sort of really sort of pivot off of is the Massachusetts Jacobson case, or Jacobson versus Massachusetts, which I think came out of Cambridge, Mass. Tell us about that case, but then if you could, like, track how the 14th Amendment gets sort of reversed. And I wonder if also, these amendments, I'm putting too much on your plate right now, but Justice KBJ made the point in a case about affirmative action that these amendments were specifically meant not to be colorblind, that they were in fact, color conscious. They were made to, in many respects, take freed slaves and make them full citizens, because they were a specific cohort. But that wasn't. It's more than implicit, but it's not quite explicit. And so that failure of making that explicit gave room for the 14th Amendment to be sort of twisted in some ways that ultimately lead to where we are now. But I'm sorry, go maybe start with Jacobson.
Yeah, so Jacobson is from 1905, and it dealt with a vaccine mandate. The state of Massachusetts gave local boards of health the authority to impose vaccine mandates. And these mandates were much more intrusive in some way than the ones we're accustomed to. These were anybody walking in the city of Cambridge had to be vaccinated or show proof of vaccination or pay a fine, but it was a criminal fine. And there was a lot of resistance at the time. There was an organized anti-vaccination movement. Some things are new and some things are not. And organized resistance to vaccines go way back. And Jacobson and other co-defendants refused to pay the fine. They were charged. They defended their case in criminal court, arguing that the Constitution gave them the right of liberty and that the mandate violated their rights. And the case eventually the state courts disagreed with Jacobson, and the case eventually made its way to the Supreme Court. And the Supreme Court, in a 7-2 decision by Justice Harlan, affirmed the state's power to mandate the vaccine. And for a long time, Jacobson has been one of probably the most cited, the most relied upon case about the government's power to protect health, especially against communicable diseases. What's really interesting about Jacobson is that it's at this moment where the court is both looking backwards to the older jurisprudence and forward to the newer jurisprudence. And the backward jurisprudence, which is, I think, most of the opinion, doesn't ask what is the nature of Jacobson's right. Does he have a fundamental right? Like, that kind of language is not accessible to the court in 1905. Jacobson himself was a pastor. He had religious objections to vaccines, but it wasn't a religious liberty case. It was just the 14th Amendment protects me. And the court said, no, the 14th Amendment doesn't protect you because the state has the right to make reasonable public health regulations. The liberty that you have does not only exist against the state, but Harlan says real liberty depends on law. It depends, right? The liberty, so there's this theory of a social contract in Jacobson, right? You get benefits from being in a society where others don't have smallpox, right? Your risk of dying is a lot less because everyone's protected against smallpox. That's your real liberty. But Jacobson also foreshadows the jurisprudence that we are more familiar with and looks to the future and says, well, yeah, but there might be a sphere of individual liberty. And maybe in some case, not this one, but sometimes the state might violate that. And if the state acted arbitrarily or capriciously or oppressively in a particular case. So it foreshadows where the court ends up going in the second half of the 20th century with this idea of individual autonomy. But what I want to stress is pre-Jacobson, that idea of bodily autonomy, that I get to do with my body what I want to do, that's just not really in our jurisprudence.
And I mean, it also strikes me that forward-looking jurisprudence that you're talking about is forward-looking only in the sense that it was perhaps opportunistic for those in the future who wanted to develop that right, because it seems to me it's just as easily argued that the reason why they also cite the idea that there are instances where you do have a certain amount of freedom is probably, to my mind, looking back on the fact that we are 30, 40 years out at that point from having enslaved people. And that it could be like, if we were really, harming your individual liberty that had no sort of like a benefit to the greater good, that would be the issue. But I guess it's irrelevant as to what the intent of the court was at that time, and more relevant as to how it's used in the future. But where did this concept, and we're getting into sort of like negative rights versus positive rights, and if you could maybe explain that idea, and where did this start to creep up? They saw that little opening in Jacobson, but what happened in society and the law, which I think are, in politics in the law and in economics in the law, that created this new development in our society.
Right. So what are negative rights? To oversimplify a little, we say negative rights are freedoms from the government, right? Keep your hands off of me, government. I want to do what I want to do, and the government can't stop me, right? And that idea sort of assumes people are isolated from the government, isolated from society. They have their own preferences. They have their own autonomy, right? It's a very common view. Positive rights are rights, sometimes we would say are rights to benefits, but not just benefits, right? Rights to health, rights, but not just health insurance, right? Right to live, things that we can't, it's the freedom that we get from living in a society. It's the freedom that we get. I can do my own thing, not because I'm left alone, but I can do my own thing because I'm not going to die of smallpox because smallpox isn't prevalent all around me. It's not raging. So where did these rights come from? I mean, liberal theory, right? You can see it in John Stuart Mill. You can see it arising with the rise of contemporary, capitalism and the movement away from a more regulated economy. We can also, and you point to Civil War and Reconstruction. I also try to make the argument in the book, right, that in fact, the reducing prevalence of contagion makes it easier for us to believe in our independence. So in the early 19th century and earlier, communities were just completely, repeatedly devastated to degrees that we cannot understand by cholera, yellow fever, smallpox. These waves of epidemics would come through, and people were really, they didn't really understand where these diseases came from, but they also did understand that most people could not protect themselves, right? In that world of contagion, our interrelationship is, I think, easier to understand than we see it today. So what starts to happen post-Reconstruction, and I think, here I might differ with you a little, is less the looking back to understanding what the Reconstruction framers meant, although maybe Harlan did, but it's more you get this increasing move towards one, business interests challenging and trying to use the 14th Amendment to limit state regulations as we move to a more capitalistic society. And at the same time, a movement away from public health to seeing health in an individualistic term. Go to my doctor when I'm sick. I don't need the state to regulate stuff. I go to my doctor when I'm sick. And you get to this more and more increasingly individualistic approach. And we begin to get more and more emphasis on the development of rights against the state by freedom of speech, freedom of religion. These weren't, we can point to them in the Constitution, but they didn't apply against the states in 1905. And so we get this churn, and you said earlier, upended. I think what we really get is a flip. And so today, instead of asking what's the state's interest as the first question, courts say, what's the individual right? Religion, speech, Second Amendment, right? We focus on our rights, not the state's interest.
And this happens, and I mean, as you say, the thing about contagion, it never really occurred to me that this is a much more sort of like devastating force in that era, that people are willing to realize that it's beyond an individual's control. As to whether they're any individual, whether they're rich or poor, or whether they, they don't have the opportunity to work at home. So it's like, if you're going to work, you're going to be working. You're not going to be doing it over Zoom. I would imagine too things like the Great Fire of Chicago, and like it gives an example of, we really need to be communitarian if we're going to fight these things. But as technology develops, as wealth disparity increases, there are certain cohorts are like, I really don't need it. I can have my own fire department if I really wanted to. We in this gated community, and I can go in on Zoom, and I don't need to have this communitarian response. Because I mean, you say this develops in the in that early 20th century, and this is obviously like the sort of a big robber baron era, but then we go into an era of during World War II, where we have Roosevelt really espousing the idea of positive rights in his Four Freedoms speech. It carries a lot of weight. But then coming out of World War II, do we see any type of like legal cases that mark this transition to where we get into, I don't know, the past 20 years, where this idea of like religious liberty and like even movements of corporations to say like, you're telling us to have our employees wash their hands, but you're imposing on our First Amendment rights to not tell them to say that, to do that.
Yeah. So, the movement towards individual rights started long before the Roberts Court, long before COVID, right? And, we see it in the social movements of the 60s, challenge authority, individual rights, allow for dissent, recalibration, even in the Warren courts against some of the very problematic aspects of the early jurisprudence. And that was in accord with Roosevelt's and the New Deal agenda. Where I think things sort of go further is it's relatively recent that the court starts applying those individual rights as trumps on what I would call core public health powers, right? So, you used to court, even back, the Rehnquist court is clear, no positive rights, First Amendment is protected, free speech. We see this in the second half of the 20th century. But now we get it even to, in the middle of a pandemic, religious liberty overrides law, stay-at-home laws, right? Religious liberty overrides laws to close schools. So now we go from recognizing those rights and rejecting the idea of positive rights, which goes back to the Rehnquist court, to now going to the place where we say, even in a pandemic, where the court says states, can't, at least not the Supreme Court, but some lower courts reading the Supreme Courts, can't have vaccine mandates without allowing anyone who has a religious exemption to opt out. Right. So now we're kind of going, and that's what you said earlier, the flip. We've gone, from perhaps overly deferring to public health laws to now kind of giving them almost no weight if someone has an individual claim that the court recognizes.
How did the court manage to take the idea of the country, the government is not allowed to acknowledge a specific religion or promote a specific religion, or inhibit the practice of it, to this is a get out of jail or get out of law free card that is waved around? And how is it that religion is privileged over just like, I don't like this law?
Right. Now, the short answer that the justices who take this view will tell you is because religion's in the first text, free exercise is in the text of the First Amendment, and so it is. On the other hand, that text has been around for a real long time, and even as recently as 1990, just in an opinion by Justice Scalia, the court said that if a law was generally applicable and neutral as to religion, so everyone needs to be vaccinated, no right for someone to opt out because of their religion. But we start in the Roberts Court seeing the justices moving away from that and beginning to really privilege free exercise claims to where it has become today. And I love the way you said it, opt out of law card. And in the book, I give the hypothetical, could you get out of traffic laws? If you say, well, my God tells me I need to go through red lights. My religion says I got to get to worship fast. So my religion overrides. And, there are nuances to the doctrine that I'm not going through now, but at its simplest, that's the place where this court seems to be pushing us. And that is so antithetical to this early idea that in a sense we're all in it together, right? We're not all in together, because if I want to speed through the intersection because I want to worship, or I want to not be vaccinated and give you my smallpox, well, we're not in it together because my religious right overrides your right to be healthy or safe or not be killed in a car crash.
so much of this is a function of like what 5 or 6 people are who are on the court, who has appointed them. Frankly, it is almost, I'd say, like a 99% I've found in my experience when reporting or reading about court cases. If you tell me who appointed the judges, I can tell you what the outcome of that case is going to be on these sort of like top line cases. I mean, it's just at least the ones that, I read, and, maybe those are a self-selected group of cases. But how much of this sort of like religious freedom doctrine is ultimately sort of the tip of the spear to completely, or as much as possible, eliminate the ability of the federal government, or any government for that matter, to do things like regulation. Because on one hand, this assault on, and there's sort of like a unvirtuous circle in terms of the way that this is absorbed by the public and then sort of spit back in terms of like what our culture accepts. And, we just heard a case in, that may end up ending the Chevron deference doctrine, which is about essentially the government's ability, as opposed to the court's diktat, as to, how far the executive branch can go in regulating without there being a specific, an incredibly, almost impossibly specific mandate from Congress. This seems to be part of the same movement. It's just different flavors with the same goal.
Sure. So first, I guess I'm going to push back at you a little about the judges. I think that's who appointed the judge. That's clearly true now. I don't think it was always true. I think things were a little bit more ambiguous once upon a time. As I said, Scalia wrote the decision to clarify that facially neutral laws do not give away to religious claims. So things are become more partisan in the judiciary. And there's no question that if, a COVID measure came up, if you told me it was a Trump judge, I pretty much knew the way it was going to go. If you told me it was an Obama judge, I probably knew the way it was going. So clearly true today, less true once upon a time. Second, partisanship. And
that once upon a time, though, I mean, not to harp too much on it, we're talking like maybe 70s. I mean, how far back are we going? Because I still see it to the extent that we have that many Reagan judges on there. They will be the most surprising to me when they have a case. But a lot of those judges now are, well into their 80s, and increasingly, as the rise of the Federalist movement, essentially, by the time we get to the aughts, it's pretty clear, Harriet Miers is not a Supreme Court justice now. Let's put it that way.
Right. I think it's hard for me to give it a date, right?
Right.
I think you're
fair
right.
enough.
I think, we start to see an increasing partisanship. And I think in some sense, the pandemic cases were the last ones to fall, right? Because once upon a time, you would have said, if there was any place that wasn't going to be partisan, it would be a pandemic. And so when you start seeing these very highly partisan alignments in the middle of a pandemic, you can sort of say, oops, we've really gone all the way now. But I don't think, I don't think we had gone all the way 30 years ago. Okay, so I can't give it a date because it's moving. But I think, I forgot the other question you asked.
Well, essentially, are these? Is this what we're seeing in the context of, let's say, the Chevron doctrine, Chevron deference doctrine, and religious freedom? Really, now just a concerted effort to get to us to a place. And again, like I would not be surprised. This had been floating around for about 10 years, this idea of like, it's a First Amendment infringement upon my rights as a corporation to force me to say, I don't know, worker protection or customer protection regulations. Like, you can't force me to put a sign up in my bathroom that says employees must wash their hands. It's
right. Yeah, no, I do.
I
absolutely think this is part of a larger, longer, broader conservative legal movement that has been challenging the regulatory state from numerous different angles. It's also related, I think, to what we see as the, if I could call it, the marriage, right, between the social conservative movements, right, who care about things like vaccines and church closings during pandemic, and the more economic, right, deregulatory movement that doesn't want environmental regulations. And one of the points I made in the book was, I think it's ironic, but the pandemic decisions giving people rights against the state during the pandemic is then used by the court and lower courts to stop environmental regulations and regulations that were designed to slow down global climate change, right? So, and again, I think it's a little ironic because once upon a time you would have thought if the government could do anything, surely they could step in during a pandemic. But it turns out that these social cases that are about ostensibly religious freedom become the cases, some of them, that then become the vehicle for going after a wide array of regulations. And it is certainly related to the attack on the Chevron doctrine, although to be, clear, the Chevron doctrine itself has sort of been so much pushed to a side with the major questions doctrine, which the court used during the pandemic to stop CDC from having an eviction moratorium, to stop OSHA from protecting workers, essential workers during the pandemic. That to some extent, the attack on Chevron feels a little redundant right now.
It's almost rear guard.
These are all connected. These are absolutely all connected.
Are there specific cases for those of us who are less adept at these things? How does a ruling saying that the U.S. government cannot say that there is a vaccine mandate, or more specifically, the U.S. government cannot say that we're going to fine, that you have a choice, either pay a fine, I can't remember exactly what it was, pay a fine or make sure that 95% or 100% of your employees were vaccinated. It was an either or situation. So it wasn't like technically a mandate. It was more of like a vaccine ultimatum option type of thing. How does that translate into, although, like fighting against that, it seems to me, is just really doing capitalists and people who want, commerce to continue unfettered its own work. But how does that concept then translate into that other space that fights against, environmental regulations or any other type of regulations?
So it has to do with how the court decided to read the statutory authority. So in the case you just cited, and by the way, the mandate was either a mask, you require your workers to be tested and masked, or you require them to be vaccinated. So an employer could just require masking and testing, right? Executive agencies only have the authority granted to them by statute. And most of these health statutes have these broad powers, and they'll say, and I'm just paraphrasing, such other measures as necessary to protect health, right? They don't necessarily lay out with enormous specificity every measure that can be taken. And of course they can't do that because, who could foresee that the pandemic would be this pandemic and not some different kind of pandemic, right? I mean, health crises vary. In the COVID cases that challenged Biden's orders, the Supreme Court began to adopt this view that you could see in a few earlier cases, but they really formalized it, which they now call the major questions doctrine, which is if a regulation will have a major impact, if it's major, whatever that means, a huge effect on the economy, political, social, whatever, it's not completely clear. The agency, in that case, OSHA, cannot issue the regulation unless they can point to a specific grant of statutory authority that says you can do exactly this, even though there might be language that says, and such other measures as the agency feels reasonably necessary. And so the court does this under the major questions doctrine. And what they claim, and this is where I think it's pretty disingenuous, they claim that they're doing this to keep the executive branch from overriding Congress, but they're really also handcuffing Congress, right? Because now Congress can only set up an agency to protect workers' health if they specify each particular measure. And it really makes it very difficult. And during the pandemic, the Supreme Court issued two such decisions, one about the eviction moratorium and one about the testing or vaccine mandate. But lower courts use this in a wide range of other to enjoin other pandemic measures, including CDC's mask mandate that you have to wear a mask on an airplane, including that the federal workers had to be vaccinated. So it really kind of put a lot of Biden administration's attempt to deal with the Delta variant and then the Omicron rise, it really just, again, handcuffed their ability to respond to the pandemic starting in late 21 into 22.
I suspect that I see these things as more political, not being a constitutional law professor. But with that said, and that granted, do you see any pushback within the legal institution or any type of concerted effort to, and I don't know how sophisticated, frankly, the Federalist Society and the right-wing legal movement, how sophisticated their plans were insofar as if you have to come up with something like the major question doctrine, you haven't done a lot of rigorous intellectual planning for this. You basically just said oh no, we have a wild card. And we can do whatever we want, but we just called it the major questions doctrine. We've more or less made this thing up out of whole cloth. There was 10 years of maybe a little bit of stitching, and then we just sort of expanded it into this sort of it covers everything. And so it's not like they did a rigorous intellectual, if this, then this, then this, then this. I mean, when you got to go to it's a big question, so we're going to decide it. But is there any, within the legal profession, is there any type of legal thought that is pushing back on this?
Well, of course, absolutely. There's some, little shameless advertising. We're putting together, my colleagues and I, a meeting in the spring to try to respond. Others certainly have. There's a lot of scholarship going on. I think so, but I think we need to be honest and say there's a lot more money behind, right? So politics has a lot to do with this. So does economics, right? I mean, I don't think we can actually separate the judicial decisions from all of these interrelated factors. The partisan divide in the country has something to do with it. I do think we see a few signs that the Supreme Court has at least taken its foot off the pedal a little bit since since Dobbs, since all the revelations about the justices, we're seeing less use of the emergency docket to come in and make major decisions. They're being a little bit more modest or a little bit more temperate, at least in some of their actions, although I'm not sure they're going to actually do it in terms of the final doctrine. But, during from the time Amy Coney Barrett joined the High Court, which is really where I start my book.
Which we should say also almost coincides 1-to-1 with Biden, with the Biden administration starting, because people forget it was 3 weeks. She's confirmed 3 weeks, I think before the election, if I remember correctly. So it's more or less like, the court really starts revving up at that point.
Right. So from that moment until Dobbs, which is really the period where I focus on when I'm not doing the history part of the book, the court was on the fast track to destabilize our law. And part of what I want to suggest is that sort of aggressive destabilization, that aggressive disregard for precedent, pushing stuff aside, sort of the bull in the china shop approach, that I think most of the public saw in Dobbs, really started in November of 2020, right, 2 weeks after the election, right when her first major decision the court issues with her on the bench. And for 2 years, they were in a real hurry to reverse a lot of things. And the roots of some of those reversals come earlier. And what I try to show is that the roots of our vulnerabilities to COVID and to our the erosion of our democracy, which I talk about in the last chapter, were there earlier, but they were high speeding through it and disregarding and overturning case after case after case. And many of them were really important. They're just not as well known. So Jacobson went from being really followed by all the lower courts to kind of pushed into the dustbin. They never overruled it. They just ignored it. The Scalia decision I talked about, they didn't overrule it. They explicitly said they didn't overrule it, but they, again, ignored, disregarded its teachings. And we can go case after case after case that they did that. They did it with the major questions doctrine. So they were kind of a bit on a rampage for 2 years and left us, I think, with a very frayed social contract. Our health is vulnerable and our polity is vulnerable.
Well, Wendy Parmet, professor of law, public policy, and urban affairs at Northeastern University. The book is Constitutional Contagion, COVID, the Courts, and Public Health. Thanks so much for your time today. Little distressing, but I find that every time I talk about the court system these days, it's increasingly distressing, but really helpful to understand. And thank you so much for your time today.
Thank you so much for having me. It's been great talking with you.